Wishing all the members of the bar a very happy Onam.
Happy Onam to your lordships, my lord, all your lordships.
My lord, may I have your lordship permission to mention an exceptionally urgent matter in the category, my lord? I sent the mail yesterday for a demolition today, my lord.
Send the mail. What time did you send the mail yesterday?
3 o'clock, my lord. Yesterday, 3
p.m. Order must have already been passed in the night because I was doing that until late.
Because we are yesterday.
Impossible. Every mail which came, there's an order, but I'll check at lunch.
Very good. I'm grateful to her. I'll give the details to the postmaster. I'm grateful.
May it please your lordship. My lord, I will cover only 3 points now, my lord. The interpretation of Article 370, which according to us is the correct interpretation, subject to, my lord, meeting with your lordship's approval. Second, State Reorganization Act. And third, what are the parameters of the power of legislation during Article 356 is in force? There are some judgments which would render assistance to your lordships, and my lord, I would read those judgments. Lord, before I start with 370, Lord, your lordships would recall the submission made by some of the learned councils, my lord, on the other side was that there was an assurance given to the princely states and
Assurances in the statute.
there was an assurance given to the princely states as a result of which, and according to the petitioner, in lieu of which, they chose to join the Union of India, and therefore Article 370 is the result of that promise which the Dominion of India then and subsequently Union of India made, and therefore 370 is to be treated as permanent.
Yes.
I'll deal with that contention first because then, my lord, 370, it would be easier for me, my lord, to persuade your lordships the view which, according to the government, is the correct view of interpretation. Lord, this question arose for the first time in the case of Madhav Rao Scindia, where the government withdrew the privy purses. At the privy purses were a bargain in lieu of which the princely state acceded to Union of India. There were two constitutional provisions, namely Article 291 and 362, which provided for the privy purses. But the central government exercised the powers under Article 366 and deleted the term princely states and construed that since princely states no longer exist, there is no question of privy purses or other privileges. The definition was princes. The lordships are not required to go into that question right now. Lord, this honorable court allowed that petition that so long as these two provisions remain on the constitution, you cannot take away the privy purses by merely changing Article 366, which is the definition clause.
Their contention is that this is what has been done by altering Article 367.
Yes.
In our case, they are trying to bring our case on parity with the privy purses case
also,
one.
Yes, but their main plank of the contention is that this was 370 was in lieu of our exceeding, right, and therefore you could not have done it. But after the judgment in Madhav Rao Scindia, the government repealed or
that is a constitutional amendment.
Constitutional amendment under 360, correct. Lord, I'm saying that, Mr. Shankar Narayan. I was just about to answer that. It was a constitutional amendment. Lord, government repealed that. So the root was taken away. That is namely Article 291 and 362. That came to be challenged before this honorable court, and the matter went before the Constitution bench in case of Raghunath Rao Ganpat Rao versus Union of India, my lords. The judgment which your lordships would find
Raghunath Ganpat Rao?
Raghunath Rao Ganpat Rao versus Union of India. 1994, supplementary 1 SCC 191.
But will we not also have to look at the original Madhav Rao Scindia?
It is discussed here.
Okay.
It is discussed here and distinguished.
Because Madhav Rao Scindia places limitations on the power of the union government to use the route of an interpretation or definition provision to abrogate substantive constitutional rights.
That is absolutely a correct legal position, but for 370, which provides that you can use this.
That's the distinction you're making.
That's the distinction, but there is one more distinction.
But you'll have to then deal with the point as to why was it necessary to take recourse to 367 then?
That when I come to 370 the interpretation, I'll deal with that. But here, in substance, if I were to summarize the ratio of this judgment in one line, the court said that any change in the constitution which brings everyone at par can never be faulted with. Princely states after formation of the Constitution of India lost their special status, and the word fraternity used in the preamble has to be given some meaning, and this has the impact of bringing all citizens at par. My lord, kindly see, my lord, that is volume 7.
Where will we find that in the case law compilation?
Lord, volume 7 of case law compilation, PDF page 537. My lord, I'll read relevant part, my lord, considering, my lord, the time constraint. I intend to complete, my lord, on this side of the lunch, my lord.
So, Solicitor, we'd also, after you finish this, go back to Madhav Rao 1.
Correct.
Because if you don't go through it, then, there'll be there'll be a front in the rejoinder that, you have not dealt with Madhav Rao 1.
Correct. But let us see how Madhav Rao
is dealt with
here, my lord, first of all. But I will go to Madhav Rao 1, but there is nothing, because that, my lord, kindly come to page 1. so that your lordships have, my lord, the background. The two writ petitions, your lordships gets, my lord, it's paid 543, PDF 543. Your lordship gets that, my lord? Yes, I am just. These two writ petitions call in question the constitutional validity of the Constitution 26th Amendment
Just
Act.
1 second, 1 second.
I'm sorry, my Lord Justice Gawai and Justice Suryakant, my Lord gets. Volumes, Case Law Volume 7 at 543, my lords, the beginning of the judgment.
Yes.
These two writ petitions call in question the constitutional validity of the Constitution 26th Amendment Act inter alia on the ground that it violates the basic structure and essential feature of the Constitution of India and is therefore outside the scope and ambit of constituent powers under Article 368. In addition, certain directions or suitable orders are sought for declaring that petitioners continue to be the rulers of the successor rulers or the successor rulers, as the case may be, and directing the respondent Union of India to continue to recognize their personal rights, amenities, privileges as rulers of their erstwhile state and also continue to pay privy purses. Your Lordships, may my Lord kindly come to the bottom of the para, which starts with, my Lord, by the said instrument, the petitioner accepted the matter specified. Does your Lordship get, my Lord, some 10th para from the bottom? My Lord Justice Gawai, my Lord, and by the said instrument, the petitioner accepted the matters specified in schedule thereto as matters with respect to which the Dominion legislature may make laws for the state and declared his intent that the Governor General of India, the Dominion legislature, the federal court, and any other Dominion authority.
I couldn't get that.
Where are you reading? I'm sorry, my Lord. I'm reading at, my Lord, page 543. My Lord, paragraph 3 at classitum F.
F, yes.
Classitum F, my Lord, your Lordship, just one line above classitum F.
By the said instrument.
By the said instrument. My Lord, court is referring to the instrument of accession signed by
As the IOA, Instrument of Accession.
Sri Raghunath Rao, my Lord, or maybe his my Lord, ancestor. By the said instrument, the petitioner accepted the matters specified in the schedule thereto as matters with respect to which the Dominion legislature may make laws for the state and declared his intent that the Governor General of India, the Dominion legislature, the federal court, and any other Dominion authority established for the purpose of Dominion shall, subject to terms of the instrument exercise in relation to Gurundwad state, such functions as may be vested in so and so, so and so, so and so of the instrument, provided that nothing therein shall be deemed to commit the ruler in any way to acceptance of any future constitution of India or to fetter his discretion to enter into agreements with the government of India under any such future constitution. Subsequently, a number of rulers executed agreements of merger and transferred the administration of their states to the Dominion of India. The merger agreement was in the form given in the white paper on Indian states and it was executed in so and so. Then, my Lord, para 4.
This one. There's a little bit of a background about Kurundwad state.
Oh,
Kurundwad is a very small town, very close to Sangli. And Kurundwad is on the banks of the river Krishna. And there's a very famous, there's a place of pilgrimage called Narsoba Chivadi, where lots of pilgrims come from across the country. And once in a year, the Krishna will rise and sweep the whole town clean, because
with the town clean.
and because the Krishna is very, and the lands are extremely fertile because of the Krishna river, right on the banks of the Krishna.
Maybe that may be the reason why the human habitation must have established there near the,
sources of water and
yes.
All earlier.
Or earlier civilizations are on the bank of
Near the rivers.
river. Look, now your lordships may come to page 548, the arguments. Here, two constitutional provisions were dispensed with were repealed by way of a definition clause. Not like, unlike Lord, interpretation clause. Lord, here kindly bear one factor in mind. 370, sub-article 3, has an inbuilt extinguishing provision. 370, sub-article 3 is a provision whereby 370 can be extinguished. That's the distinction. But I'm on a little wider argument made by the other side. Para 19, the submission, my Lord Justice. The submission advanced by Mr. Sorabji, the learned senior counsel appearing on behalf of the writ petitioner in writ petition number so-and-so are thus: Article 291, 362 and 366(2). Well, 366(2) is the definition clause defining princes then of the Constitution, were integral part of the constitutional scheme and form the important basic structure, since the underlying purpose of these articles was to facilitate submission of new order and ensure organic unity of India. These articles guaranteed pledges to the rulers based on elementary principles of justice, and in order to preserve the sanctity of solemn agreements, it was only by the incorporation of these articles that the unity of India was achieved, by getting all the rulers within the fold of the Constitution, and that the deletion of these articles has damaged and demolished the very basic structure of the Constitution. The covenants entered into were in the nature of contracts which had been guaranteed constitutionally and affirmed by making the Privy Purse an expenditure charged under the Consolidated Fund of India, and the use of expression guaranteed or assured by the Government of Dominion of India to any ruler as embodied in Article 291, and the expression guarantee and assurance given under such covenants or agreements as is referred to in Clause 1 of Article 291 as comprised in Article 362 was a permanent feature of the Constitution, reflecting the intention of the founding fathers of the Constitution, and as such, these two articles should have been kept intact. Please pause here for a minute. My Lord, these articles even remotely did not suggest that they are temporary. As against, my Lord, 370, which by its very definition says it's temporary, and I will also, my Lord, be able to attempt to demonstrate that it could never have been but for temporary. Such a drastic provision, the visionary fathers and mothers of the Constitution would never have kept it permanent, where two organs can change the Constitution the way they like. But that's a separate argument. Please see. According to the learned counsel, the deletion of these articles amounted to a gross breach of principles of political justice enshrined in the preamble by depriving or taking away from the princes the privy purses which were given to them as consideration for surrendering all their sovereign rights and contributing to the unity and integrity of the country, and that the deletion of these articles by the Impugned Amendment Act is arbitrary, unreasonable, and violative of Article 14 of the Constitution. Further, it has been urged that rulers acceded to the dominion of India and executed instrument of accession and covenants in consideration of the pledges and promises enshrined in Article 291 and 362, and that the Impugned Amendment Act is beyond and outside the scope and ambit of the constitutional power of Parliament to amend the Constitution, as provided under 368. Mr. Sorabji, in his additional written submissions, has further urged that without the cooperation of rulers, not only the territory of India, its population, the composition of the state legislatures, the Lok Sabha, the Rajya Sabha, but also constitution that was adopted on November 26, 49 would have been basically different, and that India, that is Bharat, would have been fundamentally different from the Bharat that came into being. Lord, kindly see, my Lord, para 22. Mr. Salve, the learned senior counsel, contended that he was also for the petitioner, my Lord, with Mr. my Lord Sorabji.
But estoppel doesn't apply to him.
Pardon me?
Estoppel doesn't apply to him based on what he argued in that case.
Well, that's the my Lord, privilege on this side, my Lord. We are not bound by our arguments, my Lord. Mr. Salve, learned senior counsel, contended that Article 291 and 362, when yes. Mr. Salve, the learned counsel, appearing contended that Article 291 and 362 when incorporated, were intended to grant recognition to the solemn promises on the strength of which the former rulers agreed to merge with the Indian dominion, and the guarantee of privy purses and certain privileges was as a just quid pro quo for surrendering their sovereignty and dissolving their states. It has been stated that constitutional guarantees and assurances promising continuance of privy purse as enshrined in the agreements and covenants were an integral part of the constitutional scheme and an important part of the constitutional structure, and they were to be fully honored and not cast away on a false morass of public opinion or buried under the acts of states. But the impune ex specie has abolished and destroyed those constitutional provisions of Article 291 and 362, affirming the guarantees and assurances given to the rulers under those agreements. Then your lordships may kindly come to para 23. It is further emphasized that Sardar Patel, who made it clear that according to the vision and views of the constitution makers, the guarantees of privy purses, privileges, etc., were perfectly in keeping with view the democratic ethos and principles of Indian people. Then the learned counsel stated that views expressed in the Constituent Assembly were unanimously accepted and there was no dissent, and that in fact the closing remarks in the debate of Dr. Patabi Sitaramaiah were only remarkably confirmatory of the permanence and indefeasibility of the aforesaid guarantee and assurances, but also went a long way in determining that the said guarantees and assurances have come to stay as an integral and untouchable part of the basic structure of the Constitution. Finally, it was said that there can be no basic structure of a constitution divorced from the historical evolution of precepts and principles on which the Constitution is founded. Any effort to determine the basic structure of the Constitution without keeping a finger on historical pulse of the Constitution may well lead to substantial injustice. According to him, if the historical approach to the test of basic structure is kept in view, the guarantees and assurances of the privy purses, privileges, etc., granted by the Constitution makers by incorporating Article 291, 362, and 36622 in the Constitution framed by them would, without any doubt or dispute, emerge in their own right as basic features of the Constitution, which cannot be abrogated or annihilated by any constitutional amendment, etc. Now, your lordships and my lord, kindly see para 28 at page 551. The learned Attorney General of India, with regard to the above pre-constitutional agreement, stated that history of the developments leading to the merger agreements and framing of the Constitution clearly show that it is really the union of people of native states with the people of erstwhile British India, and the instruments of accession were only the basic documents, but not the individual agreements with the rulers, and therefore to attribute the agreements entered into by rulers as a sacrifice by the rulers is unfounded. Secondly, the nature of the covenants is not that of a contract, because a contract is enforceable at law while these covenants were made non-justiciable by our constitution, vide Article 363. According to him, the covenants were political in nature and that no legal ingredients as the basis can be read into these agreements, and that the guarantees and assurances embodied in Article 291 and 362 were guarantees for the payment of privy purses. He has urged that such a guarantee can always be revoked in public interest pursuant to fulfilling a policy objective or the directive principles of the Constitution. That being so, theory of sanctity of contract or unamendability of Article 291 or 362 did not have any foundation. He continues to state that the theory of political justice is also not tenable because political justice means the principle of political equality, such as adult suffrage, democratic form of government, etc. In this context, the Lordships can skip, my Lord, the citation. Then para 29. Before embarking upon a detailed discussion on the various facets of the contentions, both factual and legal, we shall deal with the precursive point with regard to the pre-constitutional instruments of accession, the merger agreements, and the covenants which guaranteed the payment of privy purses and recognition and personal privileges, etc., and which the agreements ultimately facilitated the integration of these states with dominion of India. Then, my Lord, 30, your Lordships may skip its history. 31. This accession of Indian states to the dominion of India established a new organic relationship between the states and the government, the significance of which was forging of a constitutional link or relationship between the states and dominion of India. The accession of Indian states to dominion of India was the first phase of the process of fitting them into constitutional structure of India. The second phase involved a process of twofold integration, the consolidation of states into sizable administrative units and their democratization. Though high walls of political isolation had been raised and buttressed to prevent the infiltration of the urge for freedom and democracy into Indian states, with the advent of independence, the popular urge in the states for attaining the same measure of freedom as was enjoyed by the people in the provinces gained momentum and unleashed strong movements for the transfer of power from rulers to the people. On account of various factors working against the machinery for self-sufficient and progressive democratic setup in the smaller states and serious threat of law and order in those states, there was an integration of states, though not in a uniform pattern in all cases. Firstly, it followed the merger of states in the provinces geographically contiguous to them. Secondly, there was a conversion of states into centrally administered areas. And thirdly, the integration of their territories to create a new viable units known as Union of States. My Lord, your Lordships may, my Lord, now come to para 38, my Lord, at page, my Lord, 554, PDF 554. Now, my Lord, the Honorable Court discusses Madhav Rao, because Madhav Rao obviously was cited. That which said that privy purses are an integral part of the Constitution of India. That is one. And number two, that you could not have taken it away by merely deleting the definition of princes. These were, my Lord, the two. Then 38. On May 14, 1970, the Constitution 24th Amendment Bill for abolition of the above said privy purse, privileges, etc., conferred under Article 291, 362, and 36622 was 366-22 was introduced in Lok Sabha by the then Finance Minister Sri Chavan. The bill contained 3 clauses and a short statement of objects and reasons. The statement reads as under: the concept of rulership with privy purses and special privileges unrelated to any current function and social purposes is incompatible with an egalitarian social order. Government have therefore decided to terminate the privy purses and privileges of rulers of former Indian states. On September 2, the bill was voted upon in Lok Sabha, but on September 5, Rajya Sabha rejected the same since the bill failed in the Rajya Sabha to reach the requisite majority and not less than 2/3 present as required by Article 368 and voting. close on the heels of the said rejection, the President of India, purporting to exercise his powers under Clause 22 of Article 366 of the Constitution, signed an order withdrawing recognition of all rulers of the country en masse. Look, this was the subject matter in Madhav. A communication to this effect was sent to all rulers in India who had been previously recognized as rulers. So what was done was, by a constitutional order, which is unheard of, my lord, except in 370, the Honorable President virtually declared two provisions to be nullity. The presidential order, para 40, de-recognizing the rulers were questioned in Madhav Rao, Scindia versus Union of India, by filing writ petition under Article 32, challenging it as unconstitutional, ultra vires and void. An 11-judge bench of this court, by its judgment dated so-and-so, struck down the presidential order being illegal, ultra vires and inoperative on the ground that it had been made in violation of power of the President of India under Article 366(2) of the Constitution, and declared that writ petitions would be entitled to all their pre-existing rights and privileges, including right to privy purses, as if the impugned orders therein had not been passed. Here, it may be noted that Justice Mittar and Justice Ray gave their dissenting judgment. Thereupon, that they started getting privy purses. Lord, kindly come to para 77 at page 562. Rest, my lord, may not help, my lord, assist your lordships, my lord, either way. 77. According to Mr. Sorab, para 77.
Yes, one.
Your lordships would, I'm sorry, my apologies.
In the merger or the other agreements, that the President of India will recognize the ruler or something because of inheritance and otherwise. That was there.
Yeah,
That
but
was,
366.
there was some stipulation because those, the rule of primary nature and other things were all recognized in that. That's how.
Yes, but every ruler was
You're
apart
nodding
from.
the head because you argued that Tata.
This guaranteed them not only privy purses, some privileges.
Correct.
All states were divided into gun salute states. Some were 21 gun salute, somewhere the smallest was one gun salute.
They did refer to presidential orders in that merger agreements also. No. At that time, there won't be any president as such.
No, my lord, there was none.
No. Because at the time when the agreements were signed, there won't be a
Thereafter, the constitution was made and the honorable president was elected.
The petitioner.
No, merger agreements were signed by Dominion of India or subsequently Government of India by the Secretary, Minister of State, Ministry of State. VP Menon, Lord, essentially is the signatory.
Four and 75, make a brief reference.
Yeah.
Yes,
Para 74 and 75, there is a brief reference to all these agreements.
correct. I'm open. But your lordships are on para. But may I read para 75, my lords? May I?
Yes, para 75.
70. Therefore, there cannot be, my lord, it is on page 561. Possibly that's what, my lord, the Honorable Court is reading. Therefore, there cannot be any justification in saying that guarantees and assurances given to the rulers were sacrosanct and that Article 291 and 362 reflected only the terms of the agreement and covenants. In fact, as soon as the Constitution came into force, the memoranda of agreements executed and ratified by the State of Union of States were embodied in formal agreements under the relevant articles of the Constitution, and no obligation flowed from those agreements and covenants, but only from the constitutional provisions. To say differently, after introduction of Article 291 and 362 in the Constitution, the agreement and covenants have no existence at all. Everything gets subsumed in the Constitution itself.
In fact, that is the proclamation which Karan Singh issued after the adoption of the Indian Constitution,
49.
that thereafter the entire relationship will be governed by the Indian Constitution.
Yes.
And all previous covenants, agreements will cease to have any application.
They are, my lord, therefore, I said, my lord, it gets subsumed. And now the final document is the Constitution of India, which we have given to ourselves. To say differently, after the introduction of Article 291 and 362 in the Constitution, the agreements and covenants have no existence at all. The reference to covenants and agreements was casual and subsidiary, and the source of obligation flowed only from the Constitution. Therefore, the contention urged on the use of the words guaranteed or assured is without any force and absolutely untenable. The next vital issue is whether the Impugned Amendment Act damaged any basic structure or essential feature of the Constitution. According to Mr. Sorabji, the repeal of Article 291 and 362, which were an integral part of the constitutional scheme, the identity of the Constitution has been changed and its character has been fundamentally altered. The total repeal of these articles, coupled with an express repudiation of the guarantees embodied therein, has resulted in nullification of a just quid pro quo, which were the essence of these guarantees. He has urged that the underlying purpose of doing justice to the rulers has been subverted and breach of faith has been sanctioned. He has relied upon these judgments, including, my lord, 3 is Madhav Rao Scindia. And please see, my lord, 79. Mr. D.D. Thakur, the father of my Lord Justice Thakur. My Lord, the Chief Justice Thakur. D.D. Thakur, in addition to the above, has stated that one of the tests to determine whether the provision of the Constitution was intended to be permanent or could be deleted or amended is to see whether the Constitution makers had intended that to be made permanent. In support of this submission, he placed much reliance on the observations of Justice Mudholkar in Sajjan Singh. My Lord, I can skip that. And thereafter, my Lord, I may directly come to 88 at page 563. Your Lordship has, my Lord Justice Govai and Justice Sorry. Mr. Soli Sorabji, in support of his contention that Article 291 and Article 362 and Clause 22 of the Article 366 were integral part of the constitutional scheme, which otherwise would mean the essential part of the constitutional scheme referred to Webster's Dictionary and Collins' Concise Dictionary, and has pointed out the lexical meaning which says the integral means essential, and therefore, according to him, the total abolition of provisions of the Constitution, which are in its integral parts, otherwise essential parts, has damaged the essential and basic features of the Constitution. To draw strength for his submission, he relied upon certain observations made by Justice Shah in his judgment in Madhav Rao, observing, now Madhav Rao is dealt with and distinguished by the provisions enacted in Article 366(22), 291 and 362 of the Constitution. The privileges of rulers are made an integral part of the constitutional scheme, and an order merely derecognizing a ruler without providing for continuation of the institution of rulership, which is an integral part of the constitutional scheme, is therefore plainly illegal. The learned Attorney General has vehemently opposed the above submission, stating that the expression integral part of the scheme of the Constitution used in Madhav Rao are not the same as the basic structure, and that expression has to be read in the context of a challenge to the ordinance which sought to render nugatory certain rights guaranteed in the Constitution then existing. It is further stated that the attack on 26th Amendment based on principles laid down in Madhav Rao is totally misconceived, because only in order to overcome the effect of that judgment, the 26th Amendment was passed by Parliament in exercise of its constituent powers. The President exercised executive power, which he did not possess. Just to contrast, Article 370 has a constituent power in the President under sub-Article 3, the self-extinguishing provision. According to the Attorney General, the observations in the said case were nullified by the amendment, and the judgment is no longer good law after the amendment. To test the amendment on the basis of that judgment is impermissible, and all the arguments based upon this case are therefore misconceived. Then 91. After the commencement of the Constitution, in pursuance to Article 366(22), the rulers were recognized and they had been enjoying the privy purses, privileges, dignities, etc. on the basis of relevant constitutional provisions. Pursuant to the resolution passed by All India Congress Committee in 1967, the Union of India introduced the 24th Amendment Bill in 1970 to implement the decision of the All India Congress Committee favoring the removal of privy purses, privileges, etc. But the bill, though passed in Lok Sabha, failed to secure the requisite majority in Rajya Sabha, and therefore it lapsed. It was only thereafter that the President of India issued an order in exercise of powers vested in him under Article 366(22), changing the definition clause by an ordinance. I'm sorry, my Lord Justice.
Please continue.
I'm sorry. 36622, de-recognizing the rulers and stopping the privy purses, privileges, etc. enjoyed by the rulers. Now, this is important, my Lord. This is the distinction. This order passed by the President was the subject matter of challenge in Madhav Rao 2. The Supreme Court struck down the order of the President as invalid, as in the view of the court, de-recognition of rulers would not take away right to privy purses when Article 291 and 362 were in the Constitution. This is the ratio, that you can't delete a definition while retaining the constitutional rights guaranteed under 291 and 362. It was only in that context the observations which have been relied upon by Mr. Sorabji were made. The 26th Amendment itself was passed by Parliament to overcome the effect of this judgment. Now, by this amendment, Article 291 and 362 are omitted. Article 363A is inserted and Clause 22 of Article 366 is amended. Therefore, one cannot be allowed to say that the above said omitted articles and amended clause were the essential part of the constitutional scheme. So, they have to be read only in the context of a challenge made to the presidential order, which sought to render nugatory certain rights guaranteed in the Constitution, which were then existing. In any event, the constitutional bar of Article 363 denies the jurisdiction of any court in disputes arising from covenants and treaties executed by the rulers. The statement of objection reasons of 26th Amendment clearly points out that the retention of the above articles and continuation of the privileges and privy purses would be incompatible with the egalitarian society assured in the Constitution, and therefore, in order to remove the concept of rulership and terminate the recognition granted to ruler and abolish the privy purses, this amendment was brought. Now, 92 is very important, my lord. My lord, which would also assist your lordships on the question of federal diversity. We are of the opinion that the observations of Justice Shah in Madhav Rao that privileges of rulers are made an integral part of the constitutional scheme, and that the institution of rulership is an integral part of the constitutional scheme must be read in their proper context. That was a case whereby a presidential order, the rulers were deprived of their privy purses and other privileges while keeping Article 291 and 362 intact in the Constitution. This doesn't arise here, my lord. Indeed, the said presidential order was issued after the government failed in its attempt to effect an amendment on those lines. It is in that connection that learned judge made the above observations. It is clear that the learned judge used the word integral part in their ordinary connotation, not in lexicographical sense. Ordinarily speaking, integral means of a whole or necessary to completeness of a whole, and as forming a whole. Our Constitution is not a disjoint document. It incorporates a particular socio-economic and political philosophy. It is an integral whole. Every provision of it is an integral part of it. Even the provisions contained in Article 21, temporary, transitional, and Part 21, temporary, transitional, and special provisions. One may ask, which provision, which concept, or which institution in the Constitution is not an integral part of the Constitution? He will not find an answer. To say that a particular provision or a particular institution or concept is an integral part of the Constitution is not to say that it is an essential feature of the Constitution. Both are totally distinct and qualitatively different concepts. The said argument is really born of an attempt to read a judgment as a statute. One may tend to miss the true meaning of the decision by doing so. We may say the aforesaid observations of Justice Shah constituted the shit anchor of the petitioner's argument relating to the basic structure. My lord, just similarly, federalism is also, my lord, a basic structure. But the federal diversity can still exist within federalism. But my lord, that's a separate issue. In the above premise, it is not permissible to test 26th Amendment with reference to observations made in Madhav Rao. Lord, now kindly come to para 96 at page 566. Yeah. Permanent, your lordship, yes. Para 96 at page 566.
Yes.
Permanent retention of the privy purse and the privileges of rights would be incompatible with the sovereign and republic form of government. Such a retention will also be incompatible with the egalitarian form of our constitution. That is the opinion of the parliament, which acted to repeal the aforesaid provisions in exercise of its constituent power. The repudiation of the right of privy purse privileges, dignities, etc., by deletion of Article so and so, which the recognition of the rulers and payment of privy purse are withdrawn, cannot be said to have offended Article 14 or 19 1F. And we do not find any logic in such submission. No principle of justice, either economic, political, or social, is violated by the 26th Amendment. Political justice relates to the principles of right of the people, that is, right to universal suffrage, right to democratic form of government, and right to participation in political affairs. Economic justice is enshrined in Article 39 of the Constitution. Social justice is enshrined in, your lordships can skip that, 97. A serious argument has been advanced that the privy purse was a just quid pro quo to the rulers of Indian states for surrendering their sovereignty and rights over their territories, and that move for integration began on a positive promising note, but it soon degenerated into a game of maneuver, presumably as a deceptive plan of action. This argument, based on the ground of breaking of solemn pledges and breach of promise, cannot stand much scrutiny. To say that without voluntary accession, India, that is Bharat, would be fundamentally different from that Bharat that came into being prior to the accession is untenable, much less inconceivable. Please mark this, Malad. Beautiful words. One should not lose sight of the fact that neither because of their antipathy towards the rulers nor due to any xenophobia did the Indian government entertain the idea of integration, but because of the will of the people. It was the people of the state who were basically instrumental in integration of India. It would be apposite to refer to the observations of Justice Bose in Virender Singh judgment. Every vestige of sovereignty was abandoned by the dominion of India and the states and surrendered to the people of the land, who, through their representatives in the Constituent Assembly, hammered out for themselves a new constitution in which all were citizens in a new order, having but one tie and owing but one allegiance, devotion, loyalty, fidelity to the sovereign democratic republic that is India. Thereafter, it is also worthwhile to take note of the historical process of states integration. Lord, your lordships may directly can come to 109 at page 569, 107. On a deep your lordship gets me, my lord. Para 107. On a deep consideration of the entire scheme and content of the Constitution, we do not see any force in the above submission. In the present case, there is no question of change of identity on account of 26th Amendment. The removal of Article 291 and 362 has not made any change in the personality of the Constitution, either in its scheme or in its basic features or in its basic form or its character. But please read 370 in this. Does it change the personality of the character of the Constitution? The question of identity will arise only when there is a change in the form, character, and content of the Constitution. In fact, in the present case, the identity of the Constitution, even on the test proposed by the Council for writ petitioners and interveners, remains the same and unchanged. Sri So-and-so has contended that by removing the real and substantial distinction between erstwhile princes forming a class and the rest of citizenry of India, the constitutional amendment has at one stroke violated the basic structure of the Constitution as reflected both in Article 14 and 51C and treated unequals as equals, thereby giving a go-by to a solemn treaty obligation which was sanctified as independent constitutional guarantee. 109, Malord, this is very, very important and crucial for our purpose, Malord, the purpose of the respondents. After carefully going through the above decisions which relate to service matters, We are afraid that such an argument as one made by Sri So-and-so could not be substantiated on the principles laid down in these two decisions, that Article 14 will be violated if unequals are treated as equals. In our considered opinion, this argument is misconceived and has no relevance to the facts of the present case. Please note this. One of the objectives of the preamble of our Constitution is fraternity, assuring the dignity of the individual and the unity and integrity of the nation. It will be relevant to cite the explanation given by Dr. Ambedkar for words fraternity, explaining that fraternity means a sense of common brotherhood of all citizens. No region, no part of the region, no citizen staying in any region should get any different treatment than rest of the country. In a country like ours, with so many disruptive forces of regionalism, communalism, and linguism, it is necessary to emphasize and re-emphasize that unity and integrity of India can be preserved only by a spirit of brotherhood. India has one common citizenship, and every citizen should feel that he is Indian first, irrespective of other bases. Therefore, I started by saying that a psychological duality in the mind is now completely gone. In this view, any measure, please mark this, in this view, any measure at bringing about equality should be welcome. There is no legitimacy in the argument in favor of continuance of princely privileges, since we have held that abolition of privy purses is not violative of Article 14. It is unnecessary for us to deal with the cases cited, which according to him go to say so and so. Then 1110. One of the arguments advanced by Mr. D.D. Thakur is that the Constitution should be read in the context of a pluralistic society of India, where there are several distinct and differing interests brought together and harmonized by the Constitution makers by assuring each section, class, and society preservation of certain political, cultural, and social features specific to that class or section. By way of example, reference to Article 370, which confers a special status for Jammu and Kashmir, is made. He continues to state that likewise in the northeastern states, the tribals were given autonomous powers for their district councils co-equal to what is conferred on the states, and that the minorities special provisions are made in Article 30. Besides, Article 25 and 26 are meant to safeguard the minorities and religious denominations. The persons to determine the injury will be those for whom these provisions were made and whose interests are prejudiced. According to him, in such a circumstance, the assurance and guarantees given under Article 291 and 362, which are the Magna Carta, assuring the rulers of their pre-existing rights, cannot in any way be destroyed. We do not think that the aforesaid special provisions have any relevance here. As repeatedly pointed out supra, the only question whether there is any change in the basic structure of the Constitution by deleting Article 291 and 362 and by insertion of Article 363A and amendment of Clause 22 of 366. We have already answered this question in the negative, observing that the basic structure of the essential feature of the Constitution is or are in no way changed or altered by the impugned amendment. We cannot make surmises of its ifs and buts and arrive at conclusion that Article 291 and 362 should have been kept intact as special provisions made for minorities in the Constitution. It is but a step in the historical evolution to achieve fraternity and unity of the nation, transcending all regional, linguistic, religious, and other diversities, which are the bedrock on which the constitutional fabric has been raised. The distinction between the erstwhile rulers and the citizenry of India has to be put an end to so as to have a common brotherhood. The court traces it to fraternity mentioned in the preamble. Lord, even removal of some provision according to this judgment can further the constitutional objective and can be in furtherance of the basic structure of the Constitution. Fraternity equality is a basic structure of the Constitution. It's a part of brotherhood. It's a part of equality, part of fraternity. And if any provision which keeps out of the total composition of our Constitution as an appendage, as a transitory provision, to be removed at an appropriate stage, if it is removed, it furthers the basic structure and it enhances the equality and fraternity, which is the bedrock of the Constitution.
Yes.
So, my lord, in this view, my lord, in my respectful submission, may not be necessary to read Madhav Rao Scindia judgment. If your lordship would wish me, my lord, I can assist your lordship with that. But we will, my lord, ultimately read the same paragraphs based upon which, my lord, it is distinguished. That when you are doing something, earlier, my lord, it was done by a presidential order in Madhav Rao. One definition was deleted, which the president did never possess. Even today, it doesn't possess. But only in one provision, that is 370, where you can amend any part of the Constitution. So, explanation 367 mechanism is used. But this is the drastic nature of this provision. 371 permits two organs, the government of the president, my lord, president would mean act and advise, my lord, aid and advise, and the government of the state, again, aid and advise. My lord, please, my lord, appreciate this. Two individuals, technically, the prime minister and the chief minister of the state, whoever he is, can make any change, can make any alteration, can choose not to apply any provision, and like 35A, can create a constitutional provision only applicable to Jammu and Kashmir. That provision is exercised now as a last exercise to ensure that it never happens. 367 explanation is added. I'll come to that. Of this, but my learned friend wants me to. Yes, my lord, there is a concurring judgment, my lord.
This is Mohan.
Justice Mohan, my lord. PDF 577, my lord. Just note the paragraphs, my lord. Para 151, 152, and 118, my lords.
180.
118, my lords. PDF. Okay.
6 over.
Yes, my lords. Yes, I'm sorry, my lord. 206. Lord, it's at page, I'll just read, your lordship need not go to, it's a 2-line paragraph, my lord, but a very 594, my lord, PDF 594. This is, my lord, the concurring view, Justice Mohan, my lord, Justice Mohan. Therefore, this court cannot concern itself with the moral aspect of the impugn amendment. The impugn amendment is the will of the people expressed through Parliament. My lord, here the Parliament has examined on 4 occasions with 2/3 majority in both the houses. Lord, in Madhav Rao Scindia judgment, Lord, if your lordships can note the paragraphs which we would be reading. Lord, since it's already 11:45, my lord, I don't wish your lordships time, my lord, but if possible, my lord, conclude at 1 o'clock. Lord, in Madhav Rao Scindia, my lord, we will be relying upon 97, 109, 119, 120, 125, 126, 143 and 145
And
and 145. Well, ultimately, it turned that without deleting Article 291 and 362, whether presidential order can be used, by deleting the definition only. That was the discussion, which is distinguished, my lord, in this judgment. Now, my lord, with your lordship's permission, my lord, I may go
but,
to.
Mr. Solicitor, can the abrogation stand independent of the modification which is made to Article 367 here?
Lord, that is my submission. Lord, even in absence of the proviso, Lord, explanation, the last explanation, what it does, it merely substitutes the term constituent assembly
With legislative.
with legislative assembly. Lord, my submission is going to be that when the constituent assembly is dissolved without any recommendation, that part of the requirement goes, because proviso becoming otiose cannot result into the main provision becoming inoperative. Then the president was left to his own choice. And 367 mechanism is affirmed, my lord, in Damnu, your lordships have seen. But Lord, so far as 370
What
is,
was done in Madura was that a presidential order was issued, because if you see the provisions of Article 366,
yes,
22, as it stood prior to the amendment by the 26th Amendment. If you have this red book, it may not be in that. You will have to get it in the red book at page 372.
yes, I'll just.
That said, ruler in relation to an Indian state means the prince, chief, or other person by whom any such covenant or agreement as is referred to in clause 1 of Article 291 was entered into, and who, for the time being, is recognized by the president as the ruler of the state, and includes any person who, for the time being, is recognized by the president as a successor of such ruler.
Yes,
Now, what happened there was, initially, after the proposed amendment didn't pass muster in the Rajya Sabha, a presidential order is issued, purportedly under clause 22. And the object was, now we are de-recognizing you. If you are being de-recognized, you lose the benefit of your privy purse in Article 291. That was the
presumed to
argument.
be the consequence of de-recognition.
Right. So this was done in exercise of the power which was conferred under clause 22 as it then stood prior to the 26th Amendment. Our court said, look, by recourse to a presidential order, you cannot override a substantive provision of the Constitution, namely Article 291 and Article 362. That was Madhura's India.
Correct.
Then came the Constitutional Amendment, which was upheld against the challenge on the ground of the basic structure violation. Argument in this case is that what you have done essentially here is worse, because there was a presidential order in exercise of a provision in Article 366, which gave the president the power to recognize or de-recognize a ruler. Here what is being done is that 367 itself is sought to be amended in exercise of the, during the, we've seen the
Operating
modality.
370,
To amend 370.
which has been done consistently and affirmed by your lordships. Well, the distinction is twofold distinction. A, 370 is the only article, was the only article which permitted the president to change any other article. So 367, your lordships have shown, I have shown the chart, that 367 mechanism was used in past. That has been the convention. So the only thing which happened, my lord, on 5th and 6th of August was that using the mechanism of 367, the Constituent Assembly was changed. It is not worst. There, my lord, there is a...
The 367 mechanism which was used earlier to, for instance, substitute, the Sadari Riyasat, etc., that was with the concurrence of the assembly.
No. Only once. That was 370 sub-article 3. This, my lord, use of 367 Isma, kindly, my lord, see the distinction. What was done with the concurrence was under 370, sub-article 3. Constituent Assembly was there in 1952, it recommended and a change was made. This time, it is under 371D. Lord, this time I may emphasize, my lord, so that I'm sorry, I was not clear. I'm sorry, my lord Justice Caldwell. My lord, may I request your lordships to take 370 once again, my lord, for the time being, to make myself clear, my lord. That, my lord, would answer my lord's query, my lord, to my lord's satisfaction. Your lordships may come to, I'll show only two provisions, my lord. 371D. The lordships have 371D, my lords.
Yes.
This is the first power. Such of the other provisions of this constitution shall apply in relation to that state, subject to such exceptions and modifications as the president may by order specify. Correct, my lords? Now read 3. Kindly read 3. Notwithstanding anything in the foregoing provisions of this article, the president may, by public notification, declare that this article shall cease to be operative. That is first part. Or shall be operative only with such exceptions and modifications, and from such date as he may specify. This is the power of extinguishing or partly extinguishing. So now this is crucial, my lord, apropos my lord's question.
Yes.
The first exercise, as your lordships have rightly said, was under 3. Because the Constituent Assembly was in existence, it recommended. Rest, whenever there were modifications made in 367, were made under 1D. All rest, all under 1D, including this one,
With the concurrence of the government.
concurrence of the government.
The reason for that was very simple, because you are amending the constitution. And you are not dealing with subclause 3 of,
3, yes.
you're not dealing with subclause 3.
I'm not dealing. I dealt with at the end on, my lord, 6th of August.
Because subclause 3 only deals with 370 itself.
Itself, not other, your lordships are right, not other part of the constitution.
Because D refers to other provisions, because before D you have C.
Yes,
C says that the provisions of Article 1 and of Article 370 shall apply to the
Yes.
state of Jammu and Kashmir.
correct.
Therefore, in that sense, it freezes the provisions of Article 370 in relation to the state of Jammu and Kashmir. Now, what it does is, therefore, it says other provisions of the Constitution shall apply subject to such exceptions and modifications. Therefore, other provisions will mean provisions other than Article 1 and Article 370
And 370 itself,
and 370 itself.
correct.
Therefore, if you have to make an alteration of 370 or abrogate its status or reduce it or dilute it or alter it, you have to follow
Three.
3 equals to 3,
Correct, Manoj.
right?
But, my lord, kindly, I'm sorry, my lord, I'm almost reaching, my lord, at your lordship's level.
But then
No.
can you do that? Can you do that
Exactly, that's what I'm
using
answering.
the power under 367 then? That's the point.
Exactly, that's what I'm answering. I cannot do that under sub-article 3. 367, I cannot modify under 3 sub-article D. That I can do, and I have done only under 371D. It has been used as a mechanism, and Damnu approves it. Any-
Right, we've seen Damnu.
Any-
We are now just looking at it, we are looking at it as a matter of first impression.
Correct, Manoj. The first impression.
Can you alter the import of a provision of Article 370 itself by a process other than 3? Because what you
No.
have done essentially here is
No, no.
that you have used 367 to amend the proviso to 370.
Correct. No, not amend. 367 is explanation. That instead of A, it would be B. It may have an effect of amendment.
Whether you call it an explanation or an amendment,
Yes,
one thing is very clear, that the amendment to 367 has the consequence of now reading the words Legislative Assembly in place of Constituent Assembly.
which in fact was not necessary, but yes, it was done, but not under 370. It was done under the first step was, my lord, the first step was the president under 371D added the explanation that henceforth,
What the question being put to you is slightly, I think, different.
Ah.
The question is, by making the amendment in 366, by equating Constituent Assembly with the Legislative Assembly, aren't you in fact amending Article 370? Why, without taking recourse
to 373.
to clause 3 of 370? Because Article 370 can be only amended in terms of clause.
Because of clause 3.
I understand. But then, my lord, it has the effect of it becoming permanent. Because there is no constituent assembly. So it can never be modified. 370 can never be modified.
Can take recourse. I mean, the argument on the other side is this, that you can take recourse to clause D of subclause D of clause 1 in a situation where you have to amend any other provision of the Constitution other than Article 370.
Lord, how?
But can you take, yes,
It doesn't say so.
it's very clear. It says
Such
of
other
the
provisions.
other provisions of this
Other means except 1 and 370.
So you are saying such other
Yes.
provisions will include 367. Mr. Solicitor.
Yes, it's.
All right, Mr. Civil, just once again. That doesn't matter. Let's not.
Quite often, I think I should be accustomed to, my lord.
We are posing
Yes.
an issue because we have to deal with these issues. So we want to elicit a response.
Yes, my lord.
371D refers to other provisions of the Constitution. Other provisions of the Constitution, according to you, would include 367. Possible. We're not ruling this out at all. We'll test that hypothesis. But can you use 367 and amend 367 to bring about an amendment to 370? If you do that while exercising the power under 371D, then are you not really doing that to amend 370 itself? Because the only provision which the Constitution creates to amend 370 is 370 clause 3. What you are now doing is, according to them, is that you are using the amendment of 367, applying the provisions of 371D to bring about an amendment to 370 itself. Whereas the purpose of 371D is to amend some other provision of the Constitution. True, 367 is another provision of the Constitution, but can you use that to amend then 370 itself? That's the point which you have to answer.
Lord, I can assure my learned senior.
No, please.
No, I can assure him, nobody can disturb me or derail me without my consent. I'm quite accustomed to such interruptions.
No,
And, my lord,
Mr. Solicitor, please don't get derailed because this is the heart of the matter.
No, I know that, my lord. And he also
don't
knows
mind
that.
spending
But
5 minutes
I'm
on it
quite
because
accustomed.
some clarity on this is necessary.
Yes.
Let's sit down and do it for 5
What will
minutes
be,
and then
my lord,
just
I
do
will
this
put it
part.
slightly differently. I'll put it differently. The interpretation which your lordships are, my lord, prima facie now testing.
We're testing it.
No, we are testing it. The prima facie testing it. Lord, what will be the impact of that interpretation? I'll read, my lord, the entire Article 370. Meaning thereby, my lord, in absence of a constituent assembly, which can never be modified, the sub-article 3 can never come into effect, come into operation, and 370 gets the status of a permanent provision. Lord, please read it in totality. My lord, please read the entire article. My lord, for my satisfaction, please have a look at, my lord, the entire article. Notwithstanding anything in this constitution, your lordships can skip. The power of parliament to make laws for the said state shall be limited to those matters in the union list and concurrent list. Your lordships have seen, my lord, those the precedent
Instrument of
earmarked.
accession.
The provisions of Article 1 and of this article shall apply in relation to that state. The purpose is that Jammu and Kashmir can do nothing in their constitution, or even Parliament can do nothing in their constitution. So I highly appreciate, my lord, the difficulty, my lord, if your lordships accept that. Then even 368 route, which is the second route suggested, cannot be done. Because it says 1 and this article shall remain. If that is the meaning given, that is completely unalterable, then 370 remains as a permanent, though there are a host of considerations for me to show that it has always been a temporary feature. Further, such of the other provisions of this constitution shall apply in relation to that state, subject to such exceptions and modifications as the president may by order specify. My lord, other provisions would mean other than B.
Yeah, just stopping you for a minute. Could the Legislative Assembly make a recommendation in terms of 371A saying that under 367, you equate Constituent Assembly with Legislative Assembly?
Under 371,
What D? 370, sub clause 1, subclause D. Could the Legislative Assembly make a recommendation saying,
if it is amendment, it cannot. If it,
just think about it and then answer. Could the Legislative Assembly make a recommendation to the Parliament, please amend Article 367 and
well,
equate.
let me give it a thought and, my lord, respond to that. My lord, that I understand the heart of the matter. Your lordship's, lord, discussion, my lord, is driving that any 367 use which has the impact of altering 370 itself, my lord, then, my lord, we would be setting at not all 367 usages. My lord. But kindly remember, through the 367 mechanism, 370 has been modified.
That's the point in favor of what you are saying, with the caveat that the use of the 367 mechanism to modify 370 was always with the consent.
Concurrence.
Sorry, consent.
Here also it is concurrence. The only
It was
difference,
It was concurrent.
yes,
That's
this
the
is,
very one, that is constitutionally the significant difference.
but this
Now,
is
what
also
the
with
example we have
concurrence.
to see,
Look, this is also with concurrence. The only difference is the concurrence of the governor, because governor steps into the shoes of the government.
So there's a difference between concurrence and recommendation.
Correct. But
Concurrence
for,
can be subsequent, recommendation has to be.
no, recommendation is of the body, Constituent Assembly as it stood, and subsequently, if we are right, Legislative Assembly. Concurrence of the government. Please see, my lord. And government, the only dispute was that government cannot mean governor. Please see, my lord, concurrence provision, second
The
provision.
concurrence of the government means that Council of Ministers.
Council of Ministers, if it is there, otherwise powers are exercised by the governor. And that's why, my lord, I pointed out that there are several exercise of 371D when there was a precedence rule with concurrence of the governor.
At least you have provided yesterday.
At least,
That-
At least you have read it yesterday.
yes. Yeah, my lord, your lordship's query is, my lord, absolutely, my lord, dot on the point. But, my lord, I'll respond, my lord. Let me give it a thought. But the real question would be,
You have already responded.
well, the real question is, my lord, that here concurrence is that of the governor. Government, whichever is the government, if it is ministry, then cabinet, aid and advice, otherwise the governor. And during governor's rule, 371D is used to change 367 also. To not change, change is a incorrect word I am, to put an explanation, to give meaning to 370.
so simply put, according to you, at a time when there was no legislative assembly, the explanation was amended so as to incorporate
Democratize.
so as to provide that the Constituent Assembly shall itself be treated as the Legislative Assembly.
Because it was so treated
Because the
early.
Constitution had not been framed and there was no Legislative Assembly in the state of Jammu and Kashmir. So according to you, the flip side now is that when there is no Constituent Assembly, we treat the Legislative Assembly as the Constituent Assembly.
To democratize, my lord. Otherwise, my lord, kindly see, suppose the government took the decision. The government took the decision, my lord, suppose,
The second answer could be, and that's for the other side to answer, by amending 367, in fact, you're not really amending 370 as such, because the 370 procedure has to be still applied to abrogate or nullify 370. The procedure has to be still applied. Suppose 367 had been amended in terms of 371(1)(d), 371(d) with the concurrence of the state government. Second step, the Legislative Assembly had made a recommendation, please abandon or abrogate 370. It would have passed muster. Nobody would have really, probably the other side wouldn't have been here also, except some of them.
Yeah, they would still be here, but
So they would,
that's beside the point.
but it could have been done. If this route is permissible or not.
Lord, suppose I'm putting a question to myself. Lord, suppose
I thought I answered it in your
your
favor.
lordships are absolutely right. That's my answer, my lord. That's my answer. My lord. I'm grateful to your lordship, my lord, for that. That thought didn't occur to me. But Lord, suppose we took the decision that in view of the proviso becoming otious, because there is no constituent assembly, that limitation of recommendation, ultimately it's recommendation. Suppose it recommends that don't abrogate. President is not bound by it. So now the Constituent Assembly, having chosen while being dissolved not to recommend, the Constituent Assembly has left it to the absolute discretion of the President. It could have been done, my lord. Possibly it could have been defendable action, but with a view to ensure that there is democratization of the action. And my lord, your lordships are dealing with the state of, this is a provision which is one of its kind. There is no such provision either in our constitution or in any constitution. So the law which your lordships would ultimately lay down is not going to, Lord, touch upon any other provision. If suppose the Common Constituent Assembly, while it was being dissolved, if it framed the constitution, it had options. A, don't abolish. I am recommending that President should not exercise powers under sub-article 3. He should not abrogate 370. That was the first option. Second option, he should abrogate Article 370 after 5 years. Till then, let the Constitution continue. Third, the President is, we recommend that President should modify some of the provisions which we recommend and continue 370 as it is forever. Having done nothing of this, the Constituent Assembly goes without making any recommendation and therefore leaving it to the absolute discretion of the President.
Solicitor, you said that the president is recommendation.
It's a recommendation, my lord. It's not.
You see the words used in the proviso. Provided that the recommendation of the Constituent Assembly of the state referred to in clause 2 shall be necessary.
Yes, Lord. Why I say this, Lord, kindly see the second proviso, where concurrence word is used. Concurrence means I have to say yes, otherwise you cannot do it. Therefore, I am contrasting the word concurrence with recommendation. Consultation, yes, the concurrence is at the highest level. That without consent, concurrence means consent. Consultation may sometimes means consent, may not mean consent. Your lordship has seen Justice S.H. Sheth's transfer of judge's judgment, where it says that consultation can even mean concurrence. So I am not just contrasting the word concurrence with recommendation, that the same provision uses the word concurrence, means unless the state say yes, President can do nothing. But here same provision uses the word recommendation, that you will recommend. Ultimate power with the President who is answerable to the House which is answerable to we the people of India. So highest executive functionary is conferred with this decision, and we can read that in absence of Constituent Assembly and its recommendation, the proviso goes. It becomes redundant. It becomes otious. It becomes not possible of being implemented. And law doesn't require performance of an impossibility. But considering the nature of the strategic importance of the state, it was felt necessary that let this be debated in both the houses of parliament. And Rajya Sabha is, my lord, house of people. It has its own federal structure. Every state has a representation in a different indirect election form. And both houses passes, my lord, with 2/3 majority. My lord, even Constituent Assembly could have recommended that word temporary be deleted. Even clause 3 be deleted. Why not? There was no embargo. During the subsistence, during their existence, and while being dissolved, or during that period, they could have said that delete temporary provision, delete Article 3. Now we don't want anybody's power to abrogate. They could have said even C can be deleted. Suppose, my lord, the Constituent Assembly were to say that delete 1C, that Article 1 is untouchable. Because now we have our own constitution, we no longer are a part of, integral part of India. My lord, it could have said, technically it could have said that. But Section 3 of the Constitution says, no, we are an integral part of India. They never said that President's power under 3, we recommend being either diluted or taken away. They never wanted clause 3 to die. That's very clear.
All right. So we've covered now the first point, the interpretation of 370.
My lord, 370, my lord, there are some points. My lord, if your lordship permits.
So on 370, Mr. Solicitor, why don't you summarize in 3 or 4 propositions? What's the heart of your submission? on
Can I, my lord, do one thing if your lordship permits? My lord, I knew, my lord, I'll be running against time. My lord, instead of, my lord, my 40-50 pages of, my lord, explanation and arguments, I have summarized in 4 pages.
Right.
That would, my lord, save your lordship's time also in, my lord.
So you have it here?
If I can
Give it
be
to us so
permitted,
that,
my lord, I'll just
we can
quickly
read it
go
in
through.
5 minutes and we are done with
Yes.
370.
You can. Says, my lord, it declares it to be temporary. Your lordships may not read anything, my lord. It is contained in part 21, which has 3 categories: temporary, special provisions, and transitory provisions. So constitutional framers are aware of what word they are using. My lord, second, I have said, my lord, I have already said, and this is, my lord, something very, very serious. Look at the width of the power. 2 individuals in practice, and legally speaking, 2 organs, namely the president and the state government, can alter any part of the constitution and apply it to one part, can delete any constitutional provision, can create a new provision, and therefore, my lord, the submission is, considering the very expanse of this provision, the constituent framers would never have, my lord, contemplated this to remain forever. Such a position can never remain forever, where our constitution remains a floating document perennially for one state. Then 3, impact of Article 370 was to deprive the residents of Jammu, Kashmir and Ladakh from being treated at par with their fellow citizens. My lord, therefore, my lord, I am saying that this also is one suggestive indication that framers never intended it to be permanent. Then, Lord, this is the entire provision. Lord, this is very important. This is the entire provision in the Constitution where application of not only Constitution, please see this, my lord, the seriousness of this. Application of Constitution of India and application of central laws, including beneficial legislations, is dependent upon concurrence of the state. The only provision. It says it would not apply, it will not apply. such a, my lord, drastic provision could never have been intended to remain permanently. Then, my lord, this is the only provision which has an inbuilt self-extinguishing provision, sub-article 3. No other constitution provision has this self-destructing clause. This again, my lord, is a pointer that it was intended to be temporary. Then, my lord, it is a goal of equivalence, my lord, I have already said, my lord, in the judgment which I read, that temporary problem, my lord, provision cannot be read so as to treat one part of state differently, their citizens differently. Then, my lord, your lordships would not give interpretation to a temporary constitutional provision having such drastic consequences. Because your lordships are not going to be confronted with a similar situation in future. There is no other provision in the constitution. And to our knowledge, any other part of the world where a provision of a constitution of the main unit applies only with the state consents. In a federation like ours, there cannot be any such provisions. My lord, then I have said, my lord, kindly examine it from the people's angle. Then 370 is interpreted the way petitioners interpret. 371 would become permanent, which is not only impermissible and not envisaged, but would result in the unconstitutional provision remaining in the constitution and operating. But unconstitutional, why? It discriminates. It confers an authority which is never contemplated in other states. The application of the Constitution of India given by we the people would either not apply fully or would apply. My lord, I am on 10, point number 10. My lord, I would request if your lordships can read with me, my lord. The petitioner's assertion that such a huge decision is taken purely by an executive fiat is absolutely wrong. The process followed clearly reflects participation of entire nation through their chosen representatives, both in Lok Sabha and Rajya Sabha. When a decision becomes concerns a federating unit, it is of strategic significance, my lord, I have pointed out. My lord, then 13, my lord, is most important, my lord. Sub-article 3. The proviso to sub-article 3 was to remain in operation. My lord, I have already said these are the 5 possible recommendations that Constituent Assembly could have given. Your lordships have seen that. Then, my lord, B. Once the Jammu and Kashmir Constituent Assembly ceased to exist, the proviso to Article 370 sub-article 3 itself ceases to exist, and the President becomes the sole repository of power under Article 370 sub-article 3, which is coupled with his duty to exercise in the interest of residents of Jammu and Kashmir without any recommendation. It is for this reason that power is conferred upon the highest political executive, who is responsible to the Parliament, who in turn is responsible to we the people of India. It is thus clear that Parliament, while framing the proviso, merely gave an option to the Constituent Assembly to make recommendation till its life. But 15 is important. This is how the petitioners want your lordships to read. Notwithstanding anything in the foregoing provisions of this article, on the recommendation of the Constituent Assembly of the state referred to in clause B, the President may, by public notification, declare that this article shall cease to be operative or shall be operative only with such exceptions and modifications. The very purpose that the concept of recommendation is provided in the proviso, Lord, leads to an inevitable conclusion that they wanted it to leave it an option to the Constituent Assembly during its life to make some recommendation. Otherwise, that proviso goes. Lord, they
According to you, the proviso will not govern the substantive provision.
cannot govern. Yes, my lords are right. I am obliged, my lord. If the proviso become OTOs, the main provision does not become OTOs. Then the conditionality attached goes. Tail cannot verify. Yes, my learned friend is right. If this interpretation to Article 373 is not accepted, and the president's power is under Article 373 is taken away merely because the Constituent Assembly has ceased to exist without making any recommendation, it would create a devastating situation which could never have been envisaged by the framers of the Constitution, nor ever been conceived. If the president cannot exercise the powers under clause 3, it would mean that existence and exercise of power of the President of India provided for in the Constitution is dependent upon some decision or lack of it by a different body. My lord, can we read a constitution that president's decision is dependent upon some outside body takes a decision or does not take the decision? If it takes, it's an option. If it doesn't take, you lost your option. The President of India cannot be denuded of its power by either they giving recommendation or at least not in absence of recommendation. Such an interpretation would never be given, as such contingency could never have been, my lord, conceived. Then 17. Secondly, if mere absence of Constituent Assembly mention in the proviso to clause 3 is treated to be rendering the power of President of India nugatory, redundant, and unexercisable, it would mean that by using any provision under Article 371B and 1D, any provision of the Constitution can be amended and applied to the state of Jammu and Kashmir, and even the provisions which are part of basic structure, please mark this, my lord, this is what fell from my lord Justice called, that you are putting it at the higher threshold than the basic structure. Basic structure cannot be altered by constitutional amendment, but there is no such limitation in 1D. You can, they have chosen not to apply some of the fundamental rights, meaning thereby a permanent power is vested on two organs of the state to alter even the basic structure so far as its application to the state of Jammu and Kashmir is concerned. And this is very, very serious. Now, of course, my lord, it can never be done. Now all are at par. Even if the Constituent Assembly would have been in existence, the limited role stipulated, my lord, that I have already said, my lord, it is only recommendatory, and my lord, President could have taken any other decision.
That may not be correct actually, because so long as the Constituent Assembly, it was not recommendatory. Look at the way the article is couched. Provided that the recommendation of the Constituent Assembly of the state shall be necessary. So it's not recommendatory in that sense.
I'm sorry.
Constitution always, let's put it very, Constitution as a supreme document in a democratic country will always face restriction, whether it's the judiciary, whether it's the president, whether it's the legislature.
Lord,
It's all
I
that-
bow
that's-
down, but
that's-
my submission,
Constitution is governance by limitation, with
And,
limitation.
and the use of the words recommendation shall be necessary is a clear indication that it's not merely recommendatory, but that there has to be a recommendation before you exercise.
can your lordships read it a slight differently, the way, my lord, I read it? What is mandatory, the word shall, that you take recommendation. The recommendation is not binding, my lord. Otherwise, the Constitution would have said that it would and act accordingly. What is mandatory is taking the recommendation. That's another way of, my lord, interpreting.
So the other part of the argument, we understand that the proviso, after the Constituent Assembly had done its job, is no longer applicable, but it doesn't affect the main part. We have main clause 3, we have, we'll examine that out.
Yes. Now 19. The only constitutionally compliant way of interpreting Article 370 to achieve the ultimate goal of bringing the people of Jammu and Kashmir at par with the rest of the country and conferring them with all constitutional and statutory rights at par with the rest of the country is to either read an unfettered and plenary power of the President of India under Article 370 sub-Article 3 once the Constituent Assembly ceases to exist. Just now, Lord, I pointed that out. Or modifying the 370 sub-Article 3 by replacing the successor body. We went for the second, which according to me was not necessary. It could have been done without, my lord, any recommendation also. Lord, then power of the president under sub-article 3 is unfettered, as Article 370 starts with a non-obstante clause, notwithstanding anything contained in the Constitution of India, and sub-article 3 starts with a non-obstante clause, notwithstanding anything in the foregoing provisions of this article. But kindly see this, something that might throw some light on the first discussion which my lords, the Chief Justice, very enlightened discussion. Lord, 370 starts with a non-obstante clause. There's nothing in this constitution. This is how the 370 would function. 370 sub-article 3 starts with a non-obstante clause, notwithstanding anything in the foregoing paragraphs. Meaning thereby, even 370 can be subjected to 370 sub-article 3. Kindly read it once again. I do not know.
Obviously, because 370 clause 3 has a non-obstante clause which overrides everything else in this in this
Even
article.
1D.
Right.
Even 1D, which says that don't do anything except 1 and 3. And
There are two non-obstante clauses. The first is notwithstanding anything in this constitution. And 370 clause 3 says notwithstanding anything in this article. Therefore, it overrides, therefore, it's a power to override even clause 1.
Clause 1, yes, clause 1, 2, 2 doesn't come, Lord, 1D also. Lord, your lordships, very illuminating.
But there can't be any doubt about it, because when 370 clause 3 says notwithstanding anything in this article, that would include clause 1. There's no
Lord,
difficulty about that.
meaning thereby, modification in 370 itself was permissible through 367.
And when you override clause 1, the plain intent, therefore, is that the constitution itself becomes applicable then.
Correct.
Once you exercise the power under 3, whether there was a valid exercise is what we have to decide. But once you exercise validly the power under 3, then the constitution applies. That would be the plain consequence of it.
My Lord, your lordships may treat this as read, my Lord.
Yes, we'll read it. Let's go now to the last point.
Only, my Lord,
Now,
last
reorganization, Mr.
my Lord,
Solicitor.
last 2 pages, my Lord, last 2 pages. The status of Constituent Assembly. What was the status of Constituent Assembly? Because nomenclature is a Constituent Assembly. But whether it enjoy, my Lord, I am at the outset,
I'm not saying that it is subordinate to the Constituent Assembly for the union. I mean, you can't elevate that Constituent Assembly.
Lord, I must clarify one thing as an officer of the court. Lord, I am conscious of the principle laid down in Keshwanand Bharti, that there is a distinction between Constituent Assembly
and
and
a
Parliament.
legislative assembly.
And Parliament, or Constituent Assembly and Legislature. They are not interchangeable. That's why, my Lord, this submission, that here Constituent Assembly for all intent and purpose was a legislative assembly, not preparing a document of governance for a sovereign region, but was, my Lord, kindly see, my Lord, there are some arguments based on, my Lord, the judgment also, my Lord. My Lord, the position as far as the state of Jammu and Kashmir is concerned, even prior to coming into force of Article 1, was who created Constituent Assembly? The Maharaja, who signed instrument of accession and surrendered his sovereignty. Then he issued that proclamation. Your lordships are, my Lord, remembering that now whatever constitution is framed would be binding on him. He subsequently, my Lord, creates a constituency. So he could never have created a Constituent Assembly which would have a role independent of, larger than, or completely different from the Constituent Assembly of which he became an integral part. And at that time, my Lord, the Jammu and Kashmir was an integral part of India. So the body which was created was known as Constituent Assembly, but was a subordinate creature, then, my Lord, Constituent Assembly. And the Constitution of Jammu and Kashmir can never be put at the same pedestal as the Constitution of India, because the very birth of the Constituent Assembly of Jammu and Kashmir was because of Article 370. And, my Lord,
in other words, according to you, the role of the Constituent Assembly of Jammu and Kashmir is the role which is created for it by our constitution, by the Constitution of India,
of
nothing
India.
beyond that.
It cannot be beyond that, above that, or superior to that. It is subservient and subordinate. It never had original constituent power, my lords. Lord, please see, my lord, the constitution as we understand around the world, Lord, has certain attributes. Namely, it must be a document of governance, providing for everything, the way, my lord, we have provided. This constitution has only certain aspects. Rest, my lord, they leave it to the constitution.